Good morning, fellow commission members, staff, members, attorneys, guests. The date is Friday, February the 14th at approximately 9:30 a.m. Happy Valentine's Day to everyone. I'm Minnie Ann Lane, your commission chair, and I'll now call to order the meeting of the Tennessee Private Investigation Polygraph Commission. I'd like to request that Executive Director Cody Vest introduce our two new members to the commission and have them share with the other members just a little brief introduction about themselves.
We have Rick Jones and Jerry Richards. Mr. Jones, would you like to go first, please?
Well, certainly it's a pleasure to be here, and it's an honor. I'm really looking forward to serving. I have two daughters. One has just recently started practicing law. I'm very proud of her. And I have a younger daughter who is a student at Donaldson Christian Academy, and she aspires to go to Harvard. So I've got to make a lot of money, guys.
And my name is Jerry Richards. I have a polygraph PI business in Knoxville. I retired from the FBI in 1998. I've got 3 children and 6 grandsons. So.
Okay, I'll go further and call upon Ms. Vest to call the roll and verify quorum, please.
Larry Flair,
Here, ma'am.
David Horton,
Here.
Rick Jones, Minnie Lane,
Here.
Audrey Moore,
Here.
Jerry Richards,
Here.
Dr. Rich,
Here.
Alan Russo,
Here.
Walt Valentine.
Here.
All commission members are present, and you do have a quorum, Madam Chair.
Thank you. I'll ask if each commission member has received and reviewed a copy of the agenda, and if I can get a motion to adopt the agenda as it's presented.
So move. Second.
Motion by Dr. Rich to approve the agenda, and second by Commissioner Russo. Any discussion? All in favor?
Aye.
Opposed? Motion carried. Now, at this time, I'd like to ask our Assistant Cody Vest to handle the next item on the agenda. I believe we have someone from legal that's going to present the Sunshine Law.
Yes, sir, yes, ma'am, excuse me. Mr. Payne, would you like to, is the Tennessee Sun Law presentation with the legal division?
Yes, thank you, Cody. My name is Sam Payne, and I know I've been in one of y'all's meetings before. I can't remember whether I had any occasion to speak, but I am the Deputy General Counsel. Nancy Jones is the General Counsel, and I work directly under her. Unlike Josh Kilgore, I don't work directly with a particular board. My job is to kind of manage all the attorneys and help them be successful. I replaced Wayne Pugh. Y'all may have worked with Wayne. I've been here for about 5 months, started after Labor Day, so I'm still learning. Michael Driver is here as well. He's like me, kind of doesn't work with one particular program, but he's the chief counsel for the program attorneys, and we, as you know, kind of have a segregation. And what we call the litigating attorneys, which is when you have a contested case hearing, prosecutorial role, those attorneys. But in any event, the brains of the operation today is Damon Romano, and I'm about to turn it over to him. He prepared this PowerPoint. It's something we've presented now to a couple of other boards, and it's definitely something that if you already know something about this, it won't hurt to hear it again. And if you're a new board member, it may be a little bit of an eye-opener, but it's something you need to kind of embrace as part of being on a board. Damon is in law school at Belmont, and he's about to graduate as part of their first class, and he's done great work on this, like I said, under my supervision. But with that, I'm going to turn it over to Damon. Thanks.
Madam Chair, would you and the other commission members like to kind of maybe move off to the side so you can see that, or we do have it over here, it might be difficult to see here. I see back there?
My head might be in the way.
Well, good morning, Chair Lane and members of the commission. I appreciate your time this morning. Day to you all. Appreciate you, sir, for the
Yes.
donuts, the heart-shaped donuts. My presentation this morning will be hopefully brief. I'll leave some time, of course, to entertain whatever questions y'all may have at the end, and especially for our two new members as well. We're talking this morning about the sunshine laws, and that's really two laws. You're talking about first the Open Records Act and then the Public Meetings Act on the other side. The Open Records Act we're just going to touch on very briefly this morning. That deals mostly with Freedom of Information Act requests, public records when people request transcripts of things that you all have done. The day-to-day operation of that is mostly a staff function, and so your executive director, Ms. Vest, and her for you on a day-to-day basis. If you have, we'll touch on it a little bit, but not too much. So then the question is, what's included in open records as far as your commission is concerned? And I'll read there from the very fine print law. Public records and state records means all documents, papers, letters, maps, books, photographs, microfilms, electronic data processing, files, and output, films, sound recordings, and if that's not exhaustive enough for you, other material, regardless of physical form, et cetera, et cetera. And so the answer is what's included in open records as far as you're concerned? Pretty much everything. If you write it down, it's strongly liable to be subject to a public records request. Not constitute an incentive for you all to stop writing things down. So then we'll move into really the focus of what we're going to talk about today. That's the Public Meetings Act, and this is really where we talk about how you all do your job. Couple of aspects to this. What is the act? What is a meeting? And then what it's not. The third thing we'll look at is what's required. Once we figure out what a meeting is within the bounds of the law, we're then going to look at what you all are required to do or caused to be done by the executive director and her staff. Broad outlines, notice, agenda, public presence, allowing the public to come and participate, and minutes. You'll find that once we deal with meetings and notice, we've covered about 90% of what's required. Everything else is not window dressing. It's all very important, but once we get meetings and notice, we've gotten the bulk of it. Finally, we'll look very briefly at what happens if some act should occur that causes you all to violate the Public Meetings Act. And the answer very simply is nullity. It's as though it never happened, okay? Nobody has to, we're not going to wait for somebody to sue you and say, oh, what they did is wrong, and have the court overturn it and say, no, that doesn't matter. We're going to start from the get-go and at a meeting behind closed doors. Anything you did Public Meetings Act, the General Assembly declares it to be the policy of the state that the formation of public policy, that's going to be your adoption of rules, regulations, modifications, or amendments to those rules and regs, and decisions, pretty much everything else you do, is public business and shall not be conducted in secret. Part is really just the freedom of speech. Here is that these restrictions that are placed by virtue of you accepting to serve on this commission are not of the kind that can override your personal freedom of speech rights. How you ought to read this and how the courts have read this in the past is to say, look, we're not telling you other things, but whatever you say it on the record if you're acting in your official capacity. The act is remedial in nature, simply that we can't First example of several. It's all over the statute itself. It's all over every case that's come before the Tennessee Court of Appeals or the Tennessee Supreme Court. This language is broad. It's very expansive. It's meant to cover everything. It's designed to leave no loopholes at all. Excuse me. And again, this very broad language. All meetings of any governing body are declared to be public meetings, open to the public at all times, except as provided in the Constitution of Tennessee. That except ought to jump right out to you, and there is an exception there. There's essentially one exception. It's fairly narrow, and it's designed to aid you in the touch on that in more detail as we go on this morning. Absolutely applies to your commission. A governing body, then, if it applies to all governing bodies, well, then what's a governing body? Well, a governing body is the members of any public body, which has 2 or more members, so you all, with the authority to make decisions, which is you all, or recommendations to a public policy. If we say that a governing body is really just the members of a public body, aren't we just kind of backing the problem up one step? Then what's a public body? The point of them wording it this way is to let you know that they're trying to pick up your committees and subcommittees as well, so that you can't say, oh, well, we have to have all of our full commission meetings on the record, but we can do our committee and subcommittee meetings behind closed doors, and that's okay. No, it's not. That's what they're trying to cover here. And again, that kind of expansive language to close any kind of loophole. Excuse me. Sometimes it's easier to think about what's not a meeting than to think about what is. Let's look at that. A meeting does not include any on-site inspection of a project or a program. I don't know, to be frank with you folks, to what extent you all send out investigators to look at people's shops or things like that for continuing licensure purposes. But if you were to do something like that, or if you had a commission or board, like the Motor Vehicle Commission, routinely and regularly sends out staff investigators to inspect the premises of car dealers to make sure that they're doing everything they're supposed to be doing. That's what that is covering there. That's not a meeting. This is probably the biggest concern of most of the board members and commissioners before whom I have spoken on this topic here in the last couple of months. It says in the statute that a meeting does not include a chance meeting of 2 or more members of a public body, but no such chance meetings or informal assemblages can be used to decide or deliberate public business. This is the spirit of the law provision of the code. Okay, so if you, Commissioner Valentine, happen to run into Commissioner Rich in the Kroger or the Harris Teeter and bump into each other and say, hey, how are you? That's fine. That's not a meeting. If you pull each other aside and say, I'm glad to see you here in the Kroger. Something about some case that's before us has really been on my mind, and let me please give you my opinion about that. No. Okay. So, and by the way, and we'll talk about electronic communications, phone calls, emails, faxes, things of that nature as we move on a little bit. Just sort of a brief preview of that. If one of you undertakes to pick up the phone or to deliberately type out an email to another one of you, that's not a chance meeting, the courts have said. This one of you did it deliberately to That's not going to be covered by that exception. If you happen to share a meal together, this is where it gets a little bit body or commission may share a meal together in which you discuss public business, but it can't constitute deliberations. of time what a judge is likely to say as to whether or not a particular conversation was a discussion or a deliberation, you're smarter than I am. And the point of me saying that not a meeting. What's not a meeting are lunch breaks, restroom breaks, smoke breaks, recesses between morning and afternoon sessions. If you have a multi-day meeting and you adjourn at the end of, but of course that means if it's not a meeting, you're not allowed to discuss board business at those times. Talk about your kids, talk about the charity golf tournament coming up, lay off of board business. What kind of meetings are included? Regular meetings, special meetings also count as meetings, and I don't have it up there, but included in special meetings would be any emergency meetings that you decide to call. If you say that there is a licensee, for example, that might be doing egregiously bad stuff and we cannot wait because there's a danger, of harm to the public, and we have to get together regular meeting, that's an emergency meeting. But you'll notice that even with your emergency meetings, if you ever have those, meetings, and they have to be on the record. The only exception is the executive sessions. I mentioned a few minutes ago that we were going to talk about one narrow exception in which you could lawfully meet outside of an on-the-record, gavelled-in meeting. And this is it. This is the executive session. Executive sessions happen, or can happen, when one or more of you meets with your board's attorney, Mr. Kilgore. And if you've either been sued or you think you're about to be sued, the purpose of calling the meeting is to ask Mr. Kilgore questions related to that suit or that potential suit. Okay. Now, broader than it looks at first blush. Again, this is designed to provide you with a tool to be able to say, we're thinking about this action, or we've already taken this action. Please, Mr. Staff Attorney, please, Mr. Kilgore, tell us what the legal consequences are of that. Okay? However, again, it should be very clear that you cannot either actually before the commission or potentially before the commission. Go in and say, we think that we've got, for example, a licensee who's acting in bad faith, and these are the facts of the situation, and we think we want to discipline him. What are the consequences of that, Mr. Kilgore? And he would tell you and give you his sound legal opinion, and that's fine. If you then get that and say, and start discussing amongst yourselves, well, if that's the case, then I really think we ought to do X, or I really think we ought to do Y. No, now you've crossed the line. Now you're in deliberations. That kind of cross-talk, okay, is where we get into the deliberatory aspect of it, and where courts start becoming very concerned that that really ought to be gavelled in and on the record, okay? And so if you say we need an executive session, we're going to ask Mr. Kilgore a bunch of questions, then we're going to stop, come back into the commission room, gavel back in or get back on the record, and go forward from there. Gosh, how far does this go? Let me say, folks, that we are not trying to muzzle you, okay, or slow you down so much with bureaucratic yuck that you just can't do your jobs and perform the public service that y'all have signed on to do. But let me give you an idea of how far the courts think that this goes. This is, again, another opinion from the State Attorney General. had the Civil Service Commission in Maury County doing first cut interviews. And the people that passed those interviews would go on to the sort of vetted or approved list from which the Maury County Sheriff's Department was going to hire. Okay? The Attorney General says that even those first cut interviews that those came within the province of the Open Meetings Act. And that those interviews were required to be conducted, gavelled in on the record. Job interviews. Well, whether we think that or not, that's the broad interpretation of the law. That's how serious the legislature and the Tennessee courts are about this matter, about keeping everything above board. What the takeaway that you ought to get from this, commissioners, is that we want you to be able to do your job efficiently, or the legislature does, but being above board, getting everything on the record, keeping the proceedings as clean as possible is a higher priority for the legislature than efficiency. If one of you, I'll give you a few quick examples, if one of you emails Chair Lane and says, here's a news article about something related to our profession, that's fine. If you say, there's something that's important to me, I'd like to have that included, Madam Chair, on the next agenda, that's fine. But if you say, here's a news item about one of our licensees and we need to revoke this person, now you're giving your opinion, or you're engaging in debate about a substantive matter that is potentially before the commission. And that's, again, where you cross that line. If one of you emails another one of you, or I'm sorry, if one of you emails Mr. Kilgore, says, I have a question about the legal consequences of something we've done, something we're about to do, that's fine. That's always legitimate. That's why he's here, to give you his sound legal opinion, and you don't have to come together in order to contact him. You're allowed to do that in your ones and twos. Take to communicate with one another, that's getting problematic, and it's better if you just don't. If, for example, Commissioner Moore decides to email Commissioner Valentine to thank him for his lovely heart-shaped donuts, that's perfectly innocent, right? But before we get into reading the email, what's going to get to, frankly, what's going to get to the news outlets? The fact that you had one commissioner communicating with another off the record. That's what people are going to see first, and that's what raises a red flag. And that's what ought to raise a red flag. That's what our problem is. So it's best if you just back off of that entirely. Because even if it turns out to be perfectly innocent, it raises the appearance of impropriety. All right, let's talk briefly about electronic attendance, and this is where we try to make your lives. One or more of you can't come physically to a meeting. You may participate. All your votes have to be roll call votes. Okay, so when you're all present here, you do everything by voice vote, as you did with your minutes just a few moments ago. All in favor, aye. All opposed, nay. All right. If one or more of you is coming electronically, the public has to be able to what way, and so then you have to switch back down to roll call votes where your executive director. If you have enough people in person to make a quorum, then you can just proceed as normal. If you can only make a quorum by bringing in people telephonically, then that's when you're required, and you've probably done this once or twice, where you're required to adopt and then issue out a statement of necessity, saying, look, this is the only way that the regularly scheduled meeting, timely conducted, so on and so forth, for the benefit of our licensees and for the public. And we're going to see that the act is to be construed most favorably to the public. Excuse me. and applies to every meeting of a governing body. This case that I've cited down here at the bottom, and folks, I'm not going to try to bury you in legalese or cases this morning, but this is an interesting case. It's a perfect example of what can go wrong with the best of intentions. Here you had the Shelby County Board of Commissioners, and one of the members died, passed away while he was serving. Shelby County, west of the state, Memphis. That commissioner who had passed away in office represented an almost entirely minority district. And so 3 other commissioners got together over the phone. They just got together and they said, we have got to select a qualified member of that same community to serve on the county commission. Proper degree of diversity on the county commission. They decided, they narrowed it down to 2 or 3 people. They decided on a name. One of those commissioners said, hey, if we nominated you, would you be willing to serve? He said yes. And so they got together as a full commission. They gavelled in, had a properly noticed public meeting. The man was nominated. He was duly appointed to fill the vacancy. And then somebody sued the commission and said, wait a minute, where did this guy's name come from? There was no substantive deliberation about his qualifications or his merits or anything. Listen to the transcript, it's as though the fella, his name was pulled out of a hat and everybody just rubber stamped it, and something is fishy about that. Sure enough, the court comes back and says, that was a clear, obvious violation of the Sunshine Law. That you would have 2 or 3 commissioners go off in private and arrange who was going to sit in the vacancy on the commission. Do you think that has a big impact on the public? How that new guy's going to vote? And it was a big mess. And then what happened was that, remember we talked about before at the beginning, that if you break the law, the Sunshine Act, the penalty is nullity. It's as though it never happened. And that flows downhill. So every commission meeting in which that appointed gentleman sat, every vote he took was undone. All the work of the Shelby County Commission, that's a big city. It was as though it never happened for a period of, I think it was 6 to 8 months. And the governance of that county ground to a halt. So this is an idea of what can go wrong if we're not very scrupulous about it. All right, public attendance. The public has a right to attend and observe your meetings, but you're not required to let anybody speak. And that's for efficiency purposes. The public has a right to know what you're doing, but you're the ones who've been appointed to do it. Now, that's not to say you can't choose to allow somebody to speak. You certainly may, but you're also allowed to put reasonable time limits on it if you need to. If you say, look, folks, that we've got a busy agenda today, we'd like to have some public comment, but we've only got 20 minutes for it, and we're going to limit each of you to 60. Talk briefly about notice, and I'll run through this fairly quickly. As I mentioned at the beginning, public notice is really a staff function on a day-to-day basis, something they take care of for you. And if you have any particular questions on how that's done, you're welcome to address them to Ms. Vest. Notice has to be adequate, enough, sufficient in its contents, in its location where you put it, and its timing. Contents have to reasonably describe the purpose of the meeting. We normally do that by publishing an agenda. There's no part of the law or the rules that say you have to use the agenda format. It's just sort of what's conventional. By the way, you're not glued to the agenda either. It's not as though once you publish it, now it's graven in stone like Charlton Heston with the 10 Commandments, okay? Because there's always an item at the bottom that says, new business. Well, there's no way you can know what that is beforehand, is there? So that there gives you an idea that you can move it around. You're giving notice, not exact graven in stone notice as to what's going to be covered at the meeting. The idea is so that if the public wants to show up on an issue or item of particular interest to them, they can. Timing of the notice, you know, if you give out the notice 20 minutes before the meeting, that's not going to constitute good notice. You have to give it to them in enough time, and the rule of thumb there is about 7 to 10 days. In fact, if you go to your commission's website, and so as far as the timing of the notice, that's plenty. Lastly, location of the notice, you have to put it where somebody can see it. If you put up a perfectly adequate notice with the whole agenda in it, and you put it up 4 months in advance, and you put it in the boiler room in the basement, that's not going to work either. So this is an all of it thing. You might have seen or used to hear newspaper of public record or newspaper of general circulation. Okay, that's really something that happens at the municipal level, the county level, to deal with auctions of land, seizures of property, things like that. We now have a beautiful thing called the internet, and that is entirely sufficient as far as casting the broadest net possible to cover as many people as possible. And the belief of both the courts and the Attorney General of the state is that that's plenty. So we're publishing your agenda on, or your staff is publishing it on your commission's website, on the state's website, as I've mentioned. And then that bottom item there, bill posting, it just means stapling up a flyer. Staff usually does that on the morning of your meeting in the lobby of this building to make so that nobody can say, oh, well, I missed the meeting and it was not adequate public notice because I didn't know what room to go to, because it's a big building. We can steer people. And we talk about the Attorney General has adequacy of various media. You can use newspaper. We don't need to. Have set up, which is kind of neat. A member of the public or anybody really can sign up, and then when to come up before the board, they'll just automatically get an email sent out to them, say, hey, that thing you were interested in is about to happen. Within bounds. We're going above and beyond in terms of notice. We're almost done. In a nutshell, if you're discussing public business, it really ought to be in a meeting. We've explained what a meeting is. It's pretty much any time more than one of you is standing at the mirror staring at himself. That's a meeting, and it needs to be on the record. That language down there at the bottom, be paranoid. Gosh, maybe that's a little bit strong, but certainly be scrupulous. Question came up at another commission. What if we meet in private? What if we get together in private, off the record, travel in properly, and get on the record and repeat that same deliberation, that same debate verbatim? Now we've got it on the record. Is that going to cover us? Is that going to make it all right? In all of the cases where that issue has come up, you wouldn't be the first persons to ask it. Exactly one time has the Tennessee Court of Appeals said, okay, they fixed it later by coming back and doing it on the record. But crucially, even that one court said they clearly broke the Sunshine Law by having the meeting in secret in the first place. It's just that the bad effects of it were cured by doing it on the record. However, against that one case, there's probably a half a dozen cases, including 2 at the Tennessee State Supreme Court, that have said that is the clearest violation the most obvious violation of the Sunshine Law, because now not only are you undertaking to do your business in secret, you're trying to cover it up by pretending that you didn't do it in secret. And so the court's going to say, and the law is going to demand that if you're going to have, say, an executive session record with Mr. Kilgore, and you come back in, the court's going to say we want new and substantial deliberation sort of added to that to clarify it. And that is it. I appreciate your time this morning, Commissioners, Chair Lane. If y'all have any questions, I'd be happy to entertain them at this point. Or if you're sick of me and ready for me to go away,
Oh, you did a
I'll
damn
entertain
good
that as
job.
well.
You just did a real good job. Thank
Hey,
you.
thank you,
Thank you
Damon.
very much.
We appreciate that very much. Thank you. The next thing on our agenda is the legislative update with Greer Kelly. Is she here? No. Well, Madam Chair, we don't seem to have Ms. Greer with us right now, so we might have to move that down on the agenda. So if you'd like, we could go right ahead to our 10:30 on the agenda, which is an election of officers, meeting and everything, minutes.
We can do that.
Or we can take a short break till we can see if Ms. Kelly's coming down.
Let's take a break. I think
Okay, thank
that
you.
would be good.
I got something I need to talk to Kenny about.
I'll call the meeting back to order, and if each commission member has reviewed the minutes of the November 22nd, 2013 Private Investigation Polygraph Commission meeting, I'll ask if there's a motion to approve these minutes as they are presented.
I'll make that motion, Madam
Second.
Chairman.
Motion was made by
Horton.
Commissioner Horton, second by Commissioner Moore. Any discussion? All in favor?
Aye.
Aye.
Second here.
Excuse me.
Any opposed? The motion carries. Then we have the election of officers. You want to go on with that? Well, I will ask that our Executive Director, Cody Vess, handle that.
Thank you, Madam Chair. I do have a script, and I'm not very adept at this. I'm going to read the script, so just bear with me when you go to do your voting, please. We're going to call for nominations for the commission chair.
Nominate Minnie Lane.
Second.
Dr. Richard made the nomination. Minnie Lane has been nominated for commission chair, and it was seconded. The nomination was by Dr. Rich and second by Alan Russo. Is that correct?
Yes.
Are there any other nominations?
Move we elect her by acclamation.
Second.
Right? You just get the.
I'm sorry. I made another mistake once.
Oh, yeah, you're correct. So the motion was made by Walt Valentine, seconded by who?
Dr. Rich?
Oh, it was made
Seconded
by
by me.
Dr. Rich and seconded by Commissioner Valentine to elect Minnie Lane chair for the Private Investigation and Polygraph Commission. By acclamation. Congratulations, Ms. Lane.
Well,
Oh,
thank
you hadn't
you.
voted yet? I'm sorry. See, I got off my script, so we need to have a vote, please. All in favor?
Aye.
All opposed? Ayes have it. Now it's congratulations, Ms. Lane.
Thank you.
Congratulations.
See if I get off my script, I don't remember. Okay, now we're going to do vice chair. Do I have any nominations for vice chair?
I'll nominate Alan Russo.
Second.
Alan Russo was nominated to be vice chair of the commission, Private Investigation Commission, was seconded by Audrey Moore. Are there any other nominations?
Make a recommendation, nomination cease.
Okay. Okay, the motion was made, so it's going to be, and there's no, not anybody else, so it's going to, we're going to see if we're going to elect Commissioner Russo by acclamation. Do I have a motion?
I so move.
Do I have a second?
I'll second it.
All right, the motion was made by Dr. Rich, seconded by Larry Flair. We need to have a vote. All in favor?
Aye.
All opposed? Congratulations to Alan Russo for Vice Chair of the Private Investigation and Polygraph Commission.
That's right. Do not disappoint us.
We will have hot clock donuts every meeting, right? As a home, thank you.
Oh, there we go.
Thank you.
Well, I'd like to take this opportunity to thank everybody for your support. I'll do everything I can to handle the office the best I know how. Thank each of you. Okay, next on our agenda, we have adoption of the Roberts Rules of Order. Our Executive Director, Cody Vest, will handle that, please.
Yes, we're required every year, supposed to be at the first meeting of every year, for you to adopt the Roberts Rules of Order, with the one exception that the chair may vote.
So move.
Second.
Second.
Motion was made by Commissioner Russo, second by Commissioner Valentine. All in favor?
Aye.
Aye.
Any opposed?
No.
We have adopted Roberts Rules of Orders for the Private Investigation and Polygraph Commission, Madam Chair.
I apologize.
We don't do this very often.
No.
Once a year.
May we have legislative update as our next item, or do you want to? Okay. Are they not here yet?
He's not here yet.
He's not.
coming from the-
Okay,
We'll work it out. We sure can. I'll ask our Assistant General Counsel, Josh Kilgore, to handle that, please.
Chair, feels like it's been a long time since I've been here. This is the legal report for February 14th, 2014. Also, before I get into that, I'd like to introduce you to a new Assistant General Counsel who just came on, Ellery Richardson. She's going to be on the reg boards.
she's not going to be on this one.
Okay.
We keeping Mr.
I'm
Kilgore.
finna say, my God.
I know, he just introducing you to a new member. I know you had that look.
The first matter here is case number 2013-025361. Complaint was established when it was discovered respondent's website and phone book ads included investigators and investigation services as services offered. Respondent holds only a contract security company license through Private Protective Services. Respondent blames the web designers and the phone book company for printing false information and states that they have taken steps to remedy the situation and remove all references to investigating from the web and phone book ads. Respondent admits it was his duty as owner to check the accuracy of the website and ads, but states web designers have been fired for adding or changing website content without written approval from the authorized persons from respondent company. Therefore, my recommendation is issue a letter of warning to respondent for advertising as an investigation company without a PI company license in violation of TCA 6226-204A.
Move we adopt council's recommendation.
Second.
We have a motion by Commissioner Rich, second by Commissioner Valentine. Any discussion? All in favor?
Aye.
Motion carries to issue the letter of warning to the respondent for advertising.
Next matter is case number 2013-026231, 2 and 3. There's 3 respondents to this matter, 1 company and 2 investigators. Complaint was established alleging that investigators working for a respondent company had been assigned to work cases originating in Tennessee while only possessing Georgia licenses. Respondent company, on behalf of all respondents in this matter, states that the company's caseworker and private investigators did not understand the meaning of the term reciprocal in the context of PI licensure. Respondent states that they were of the belief that because Georgia has a reciprocal agreement with Tennessee that they could legally work here on Georgia licenses. Company states that all investigators and case managers have been advised of the reciprocal agreements and educated as to its limits. Respondent company is licensed in Tennessee. Therefore, my recommendation is issue a letter of warning to the two respondent investigators regarding improperly working without a Tennessee PI license, and authorize formal and send a consent order with a civil penalty in the amount of $500 to company for improperly assigning cases to Tennessee PIs without Tennessee licensure.
Is there a motion?
Make a motion, we accept council's recommendation.
Second.
Motion was made by, who made that motion?
I did, Flair.
By Commissioner Flair, second by Commissioner Moore. Any discussion? All in favor?
Aye.
Motion carries.
Final matter is case number 2013-023871. Complaint was established when the commission office received information that respondent was providing background screening services to many organizations in the state of Tennessee for over 10 years. Respondent admits to these allegations but states that they believe they were in compliance as they have a Florida PI license and thought they were covered under the reciprocity agreement between Tennessee and Florida. The investigations being performed appear to originate from Tennessee through requests of Tennessee organizations and are processed in Florida. The law respondent relies on has language that states all background screening will be performed by a, quote, state licensed private investigation company, and respondent asserts that this allows a company licensed in any state to engage in background screenings. This is not the case. My recommendation is authorize formal and send a consent order with a civil penalty in the amount of $5,000 for operating for at least 10 years without obtaining a valid PI company license in this state. That would break down to $500 a year. And this is their first violation, obviously.
Is there a motion?
So move.
Motion by Commissioner Flair, second by Commissioner Rousseau. Any discussion? All in favor?
Aye.
Opposed? Motion carries.
That concludes my legal report. I do have a rulemaking matter that I would like to address now, if I may.
That'll be fine.
Go back. Thank you.
Held this to you. I believe Beth sent this to you
I don't have it. I haven't sent it to him.
several months ago,
Months ago.
a couple of months ago. The military applicant rule. Have the commission members seen this before?
Yes, wasn't it last year?
While ago. For the November meeting.
This is basically language that all the regulatory board programs are trying to adopt into their rules to come into compliance with Title 4.3, 1304, subsection D1, stated there at the very top. It basically is a process by which the statute sets out that military applicants that have licenses in these professions in other states be allowed to obtain licensure in Tennessee through reciprocity if their requirements for their other license in the other state are substantially similar or, higher, if the standards are higher in the other state or substantially similar to Tennessee's, that they be allowed to be granted licensure. And if the commission feels for any reason that they don't meet those requirements, that they be allowed a temporary license. If they feel that education or more education, training, or experience is required, then they would be allowed to work under a temporary permit. This is the rule, this is the proposed language of the rule that we are proposing. What we're doing today is just the first step where we have to get the commission's approval to adopt this language as proposed, and then it has to go through the regular chain up through the Attorney General's and Governor's office before it's approved.
Question.
We need this in the form of a vote,
Well,
motion.
Yeah,
Well, I
this,
have a question.
I've got, there's questions that have to be answered about the economic impact on small businesses in Tennessee. I've gone to the liberty of going ahead and proposing some language that I can read into the record. And at the end of that, I'll ask you to discuss, if you feel like you need to discuss, any changes to that proposed language. I think this would be the most efficient way to do it.
Be fine.
Something that we're required to do. And just for the record, I'll just read, the Tennessee Private Investigation and Polygraph Commission intends to convene a rulemaking hearing on an as-yet-to-be-determined date in order to consider amending current commission rules governing the application procedure for licensure. The rules contained in the notice of rulemaking would amend the administrative rule governing application procedures by allowing a procedure for military service applicants to obtain licenses by reciprocity if they have been previously licensed in another state whose requirements are substantially equal to or greater than our own, or by issuing temporary permits in cases where it is determined more experience, training, or education is required to meet our licensing requirements. And the economic impact statement that is required to be, it's basically 6 questions that are required to be answered, considered and answered by the commission. And I'm going to go ahead and read those now. And it's all pertaining to how this may affect small businesses in the state of Tennessee. The first question is types of small businesses directly affected. There's only a possibility of allowing the startup of small businesses to be made easier by allowing military applicants easier access to reciprocal licenses. Second one is projected reporting, record keeping, and other administrative costs. And this is as it pertains to small business. There is no foreseeable alteration in small business record keeping that will result from the promulgation of these rules. Number 3, probable effect on small businesses. Allowing small businesses via their licensees easier startups due to making obtaining reciprocal licenses easier for military applicants. Number 4, less burdensome, intrusive, or costly alternative methods. I wrote, the commission knows of no other alternative method to achieve the goals exhibited by these rules. Number 5, comparison with federal and state counterparts. There are no federal counterparts to the issues addressed by these rules. Additionally, the rules impact procedures within a state agency rather than impose new or altered regulation upon private entities. And number 6, effective possible exemption of small businesses. I wrote, there will be no exemptions created by these rules. And I also want to note this would impact, that would be the same across private investigators and polygraph examiners as far as military applicants are concerned. So I'll open it up if the commission would like to discuss any of these, or if they would like to adopt the answers to the questions that I've proposed. I'll go ahead and let you discuss that.
Is there a motion?
I have a question, Mr. Kilgore.
Sir.
Under 10B2, we aren't dealing with the military in this area. Is that right? Aye. The temporary permit?
Yes, that's only a temporary permit if the commission determines that that military applicant does not meet the requirements for substantial equivalency, but that the applicant could perform additional acts such as education, training, or experience to get up to our regular standards, but that does apply to military applicants, yes, sir.
Well, C is the first time military is mentioned. It didn't mention in A or B.
Okay, I apologize. It's a little bit confusing because 10 itself is referencing TCA 43-1304, which you don't have in front of you, which that is what deals with the military. So this whole section here, number 10 down, is dealing with the military.
Okay. The temporary permit under 10B2 says that it shall be issued for a period no longer than the length of a renewal cycle for a full license of the same type. Isn't that 5 years? 2 years? That seems like a long time to issue a temporary permit. Seems like they ought to be moving toward getting all the requirements done in less than 2 years.
Well, right. It says shall be issued a period no longer than. So I think that we could limit that to a year, 6 months, if a temporary permit is issued. I don't think that says that it says for a period no longer than, so I don't think that means it has to be a full 2 years. It just means it can't exceed 2 years.
Go to 2 years. My question is, I just have a problem with a temporary permit, period. I mean, we had a big issue about a temporary permit years ago with the FBI. We wouldn't even give them a temporary permit. We wouldn't even give a person that worked with Homeland Security a temporary permit. And this permit is giving them a whole lot of wiggle room that we wouldn't even give a regular person that applies for a license with the state of Tennessee to be a private investigator. So to me, what make this so much better than just a normal person? You see, if we're going to be fair, we need to be fair to everybody. I don't see where it's just called just because a person was in the military that they get a pass. I mean,
if I can take exception to it, I don't mind having an exception for the military. It's just the term of up to 2 years. Just seems a little excessive to me.
but then he goes on down in III, and it said the licensing agency shall not be subject to renewal except through the completion of the requirement of substantial equivalency as required. That to me seems like it's saying that the agency can say, forget II and go III, you got 6 months to do it. This wasn't clear to me.
It seems like to me that's saying that the temporary
I
permit
don't think that it has to
shall
run.
expire,
Right.
and it's not subject to renewal.
It's still not clear from the first time that I saw it. It's still reading the same way. It's not making much sense. It's not relevant all the way through about military education. As Valentine said, military comes up in C. It don't even start up in 10A or B. So it's kind of confusing to me.
This is the proposed model rule language. It certainly isn't, it's most likely not the final form of this. This is, what we're doing is just trying to get approval to move forward towards something to come into compliance with 4-3-1304, which already is on the books, which says that military applicants shall be issued a reciprocal license. if they meet our minimum requirements for licensure. And that's what we're trying to accomplish today. It's still got to go through the normal rulemaking, just like any of your other rules have to.
Madam Chairman, if you will, in essence, you need a motion today and us vote on getting this door open for this to proceed down the road.
That's what I call for a motion.
Right. And also, just because we open that door today does not mean that, will this commission then have authorization or authority down the road to amend and or take a second look? Probably not.
Well, there's people up the chain that will approve whatever the language is that gets sent to them. I mean, this is already a statute that's already supposed to be, we have to comply with anyway. This is just simply us putting it into our rules so that we show compliance in our programs. But this is already passed and is already in the statute. This is simply reflecting and putting into effect the legislature's wishes.
Can I make a motion that we do accept this recommendation?
They waiver the.
Are we ready for that?
I'll call for the motion. We have a motion by
I'll second it.
Commissioner Horton to accept this. Is there a second?
I'll second it.
Second by Commissioner Flair. Any other discussion?
So they don't have to do continuing education either, it's wavered. Well, that's what it says here.
Appreciate that. Discussing the continuing education requirement.
They're wavered if they weren't able to get them due to their military service.
If they were overseas or whatever.
Yeah, it's a slippery slope, but you know, if it's already on the records, ain't nothing we can do. So it's just a slippery slope. We're gonna have a lot of backlash behind that. I just want to go on record saying that.
All in favor?
Aye.
Oppose? Motion carries.
Chairwoman, did you want to go ahead and have a motion to adopt the answers to the economic impact statement that I read?
Yes, we need to vote on that. He read the impact statement. Do I hear a motion to
I
adopt?
so move, accept.
Motion by Commissioner Russo. Is there a second?
I'll second it.
Second by Commissioner Flair. Any discussion? All in favor?
Aye.
Oppose? Motion carries.
That concludes my part for now.
Okay,
Just to make it clear, we are going to be having a agreement. That's what we want to sit down and plan to, what we can do. Got to bring every one of them before the board, for the commission. You only meet once every. There's questions we even have here in the office, how we even going to do it, or how we even going to put it on the computer system. We do have an apprentice, we have it developed in the computer, where it's we'll be talking a lot about this and getting with each member and move it pretty quickly on our rules to have this in place. But no, this conversation is not complete.
do we have anybody here for appearance yet?
To give you a little update on this, this is Mr. William Smith. He was denied based on a material misstatement that he made on his application, and he is appealing that decision. You probably will notice that your information is a little bit different. We do have to be conscious of secondary dissemination on a criminal record, so we are looking at different ways to present this to you. If you will look, the first page there is the letter that I sent out to him about it. Well, actually, I think Beth did that. Then the second one is a notice for the notice of private investigator application denial. That's where he had his written explanation. And instead of giving you the information that came from the TBI or the FBI, if you'll notice back on another page, it says notes. And that's where it says the application was denied on January the 17th of 14. He checked no to arrest. He did have a charge there on January the 13th of 03, which was actually dismissed, but it was denied for not placing it on the application, saying no, he hadn't been arrested. You'll start seeing basically this type of a sheet. You're not going to be seeing the actual criminal record. Won't be seeing all the application. They're here strictly just to.
This is the first time we've seen this. Would you care to give us just a minute to look at it?
It's fine.
Having trouble with our iPad.
We are again.
Hannah, could you come up and help with this?
Dr. Rich.
Claire, would you, Miss Hannah will help, Commissioner. Everybody got it? See, you're just too quick for us, Commissioner Flair.
Thank you.
You got magic fingers.
Come from Alabama to today's meeting?
Yes, ma'am, from Gunnersville. It was tough getting out of there, but the rest of the way was fine. All the higher mountains, I guess, over down there. Finally getting there. Been stuck at home for 3 days. Had cabin fever.
I believe most of us have read everything. Mr. Smith, would you like to go ahead and offer any explanation? What would you like to tell us about this incident?
Ma'am, that was when I received the denial letter, that was the first I had known I was arrested, ever arrested. I have checked, never had an arrest before. 3 years ago, when I went to the Federal Law Enforcement Training Center down in Brunswick, Georgia, they had me fill out the same thing. It never was caught. 2 applications since, never came up or flagged. So it was a big surprise to me when Beth sent me that going, I was like, what? You're the wrong person. But when she told me it was Rankin, Georgia, I could understand. Back on the date that it happened, I even spoke with the police chief on January 24th, and he's kind of confused about it. He's a new police chief, and he said there were a lot of problems with that department in the past, but they want me to come down there and file an expungement
standard procedure. That way it gets it off my record, because he agreed that it should have never went down as an arrest, which is why I was shocked as well. The incident in question was, I was traveling with a friend of mine on a job she had up north for a couple of days, came back that night, and her ex-boyfriend came and started causing trouble, started to swing at me. I ducked. He slipped in the gravel, fell. She called the police on him, but they took us both. But it never was fingerprinted, never was read rights, booked. I was just taken to the lobby, and actually she came from that lot and got me and took me back to get my vehicle that night. So it was just something that should have never went down as an arrest, and that's why I felt I wasn't lying when I checked arrest. If I had known about it, I'd have definitely checked arrest. Of course, by now it'd have been off my record like it's going to be when I go down there to take care of it. But it was not intentional to check no on the arrest, and that's what happened.
What about court cost and so forth? Was there any cost associated with it that you had to pay?
It was told to appear. It was actually weird because I was told by phone to appear. The other guy was charged, but I was told to appear in court and at that day, and that doesn't even show through Effingham County records that I was even in court. Weird.
Did you go to court?
Oh, yes, ma'am, just to clear my name, and the judge literally laughed at the whole thing, saying I should have never even been in the courtroom. Effingham, Georgia is just a different place. I'll put it that way, and it's just.
Do you plan to go to Georgia and get this expunged?
Oh, yes, ma'am. Yes, ma'am. Of course, then from now on, if I have to fill out anything else, I have to check arrest, and I don't like that because I felt like I've had a clean record all my life. But I'm going in the next couple of months. My dad still lives in that area. He's a retired deputy sheriff down there, and I'm gonna go down there and get it cleared. They said once I go and file for an expungement, is what they call it, it'll just wipe it off my record. They have to go down there and physically pull a criminal records background check with me present there. And then they say it takes about 4 to 6 weeks to get it off the record.
In this instance, looks like there should be something besides an expungement could be handled to.
I would think so too. I was like, well, this is legally, to me, it was something that should have never been put on the record. But
If you were never charged, then what is there to expunge?
it went down as an arrest, like Beth had told me over the phone. It went down through the federal and TBI. It came up on the records, and like I said, I've had 3 applications before. One to get onto the FLETC in Brunswick, and it's never been flagged before. All of a sudden now it's being flagged when I check arrest. I asked the chief, I said, is this unusual? He says, legally in a lot of states, which is surprising, if they detain you, just detain you, not even handcuff you or anything, they can actually put it down in the record books as an arrest, period. And that's not good. So, and that evidently was the case here. The police officer who took me to Rankin evidently put it down as an arrest. And like I said, the judge actually laughed it out of court, but the other guy was charged from what I understand, but I didn't dig deep into that.
Chairman, we have come across this situation several times, and I'm satisfied with the gentleman's explanation. So if it's appropriate, I'd like to move that we accept his application.
I have a motion to accept the application by Commissioner Russo, second by Commissioner Horton. Any further discussion?
We would like for you to notify the board when you have that expunged.
For sure. We'll definitely do. I'll contact Beth. I have her email.
All in favor of the motion?
Aye.
Opposed? Motion carries. Well, good luck to you.
Thank you.
Madam Chair, let me explain, since we do have new commission members, we will see everything that law enforcement sees. A lot of times they only will show when they do background checks, maybe 10 years, 12 years, all the way back to juvenile. Of course, we cannot consider juvenile, but our office will get, this is not unusual. We hear it all the time. I've had a background check, it never showed up, but our office gets everything that a law enforcement officers would get. Members, so they know what we get.
Is that the only appearance, or we have anybody else?
One appearance, okay, we'll just move along if you like.
Hey, what about administrative matters? Can we go to that?
Go to mine if that's all right.
Okay, if you'll handle that, I appreciate
All
it.
right, it's going to be Exhibit C, disciplinary action report, and I'm going to spend since we do have new members, I'm going to spend a little extra few minutes explaining what all disciplinary, if you look at it, you'll see that this covers all of the programs that our office regulates, or helps regulate. That's the alarm board, the locksmith, private investigation, and private protective services. First one is the alarm board. They charge a civil penalty just like we will. If you have a civil penalty, it will go on the disciplinary of warning earlier. That does not go on a disciplinary report. If you look at private investigation, Polygraph didn't have any in that month of November. Private protective services had quite a few. And now we are required to put down the student loans and the child support. That is considered disciplinary action. That's why there's quite a few there for private protective services for that month. If you look over to December, flip over to it, your first one you come to is alarms. You can see the attorney was quite busy the month of December for the alarm board. We didn't have any action on the locksmith for the new board members. The locksmith and private protective services are commissioner-run programs. That is where the staff attorney and myself go before the assistant commissioner. We have a meeting such as. We were busy there with the private investigation, Polygraph Commission. You see it here. The revocation and the suspensions, everything will go. This is all considered public record. It is on the internet. And you do have the here's your January disciplinary report for alarms. I try to present this to you every month so you can see the activity that it is. We're going to go to Exhibit D, which is the open complaint report. Well, we're just tickled to death. You don't have but 4, and we already, Attorney Kilgore presented 3, so you got 1. And I believe that one is going to a formal.
At the next meeting.
At the next meeting, you will be having, as far as we know right now, the schedule is that you will be having a formal hearing. And Beth, we probably need to send out to our new commission members any information we have on.
I'm gonna see if I can get it on those books they gave out. Here, did they give you any kind of a board member?
Before I go any further than that, just a little update. I went up to Chancery Court on another case, but it was the alarm. And listen to it. Anonymous. Your complaints are presented anonymous until it's the time for. Like the board members didn't even review the case. Well, the case was, it's just too. I asked you to vote and have discussion. We should do that as well. I just wanted to bring that up. let you know it's very important, especially going in this formal. The attorney will usually help prepare some facts and findings. And if you wish to adopt those, that's what you can adopt, or you'd have discussion and have your own. Members will know we did have a formal hearing that lasts till 7 o'clock at night, starts at 9 in the morning. But usually we have a good judge, and they'll help you along with the proceedings as well. And that will be Attorney Robin Ryan that you see that comes in. She'll be doing that for you. Okay, we'll go to E, which is your monthly reports. This is sent out, you already sent this to you.
Yeah, I sent it 3 times last week.
Okay, let's
Sorry.
send that to you. It's just, sometimes it's a little confusing, so I'm just gonna break it down. I mean, you can look at it. We're still looking for Audrey Moore's reappointment. We'll let you know that Dr. Rich was reappointed. Rick Jones did take Janice Holt's position on the commission, and Jerry Richards took Ken Shull's position on the commission. The rest of it is just information that we do, the number of complaints. Beth spends quite a bit of time doing this. How many complaints we have, how many licensees we have, any legislation that we might have at the time is in there as well. You can just take a few minutes and look at that, but like I say, we've already Okay, let's go to Exhibit F, exam stats.
See if I can get this one to open.
This is the examination statistics, and you have a new brochure behind it. You know, we've been without an exam for quite a while. We do have an exam in place, and this information covers the period of December of 13 through February of 14. We had two individuals take the polygraph exam and passed it. You had a total of 17 private investigation individuals wanting to take private investigation company exams. Well, 9 passed that. Tennessee private investigators who wanted individuals to take that exam. First time you had 28 that passed out of a total. For a total of 59. This is with PSI. We're with a different vendor now. The first time that I know that Beth is able to get this kind of information together for you. Get it from the other vendor. So hopefully we can continue to get this information and let you know. Taking this exam, we worked hard on these exams to get them up to par. It's not a real easy. We don't want it too difficult so they cannot get it. It looks like we had a pretty good first time pass ratio there. Right, and now what the other one I have is just some information for you. Alabama now has a private investigation commission. I don't know if all of you knew that or not. You can read through this material that you have there, but I'll tell you, it's practically the same as 6226-205. There is a difference there. Tennessee requires you to have 12 hours of continuing education. Alabama wants 8 hours per year. But the majority of it was copied, it looked like, exactly from our law book. And I'm finished with my portion unless somebody has a question.
Out of, you said 59 had taken the private investigator test? I'm sorry,
I think that's a look at, if we add it together.
59's just the company.
That's the company.
Yeah.
Huh?
17 have taken the PI
No,
company. 59 have taken the PI exam, and 2 polygraph.
Polygraph, so you have to add all those together. No, we just didn't add that up. Well, that was we had quite a few, 59 PIs. We had quite a few that were waiting to take that exam.
Because we were down so long, right? I mean,
Yes, we had a long time there.
I was impressed with the new company, what interaction I had with them. I
Beth's
guess.
gonna pass out, excuse me, Beth's gonna pass out some more information for you. It's about, some legislation that has been proposed, it's on the Hill. Actually affect you, but since it is your profession as private investigators and some polygraph individuals, there may be information that you'd want to know about.
There's 2 polygraph possible amendments, but they don't amend the polygraph law. I'm just giving you copies of those. And then there's one, take one of these and pass it down. And then there's one bill to regulate processor. And just because it impacts your industries, I thought we'd give you copies of these. One of these is dead, right? It doesn't have a Senate sponsor. So when you get to the end, I think I emailed Mr. Richards the polygraph ones. I might have sent them to all of you. One of them is regarding voice stress analysis, and the other one is regarding using the polygraph for pre-employment. And then the process server bill would require them to be registered through the administrative office.
Is that the one you said did not have a sponsor?
No, it's one of the polygraph bills.
Oh,
that
okay.
doesn't have a sponsor. And y'all give these all.
Commissioner Rich, go ahead. Did you? Oh, okay.
Is it not working again?
This thing's gone on permanent vacation.
It doesn't like you?
It doesn't like me at all.
Well, I think we're actually finished with using their iPads anyway.
So too. We don't have that much more. On that Alabama Senate bill, on that Alabama I can gather on the Alabama law, they don't really have their board in place yet, and it looks like most everybody down there is gonna be grandfathered. Once they do have a board in place.
That'd be good. Well, I guess next we have the education.
Since they copied your
Excuse
book.
me. Okay.
Once they cut and pasted your law.
Yeah.
Yes, Bill.
We're through with it. Next, we have the education report.
Not yet. Not yet.
Beth, could I call upon you to handle the education report?
All right. The Education Committee, which consists of Minnie Lane, Dr. Rich, David Horton, Alan Russo, and most recently Walt Valentine. I send out all the courses that we get in to the commission in advance of the meetings for them to review. We have a public meeting before every commission meeting to go over that and make recommendations, which we later deal with at a full commission meeting. We reviewed, and y'all stop me if I get to something that I don't have to correct. We reviewed a 23rd Workers' Compensation Disability Conference for John Edward Holder, just for his continuing ed. He only had 5 hours. The recommendation was that was to approve it. Deborah Hudson submitted the Citizens Police Academy in Germantown and 2 other continuing ed certificates. The Citizens Police Academy was 25 hours. The recommendation was to approve that and the 2 other 1-hour courses. Benjamin Reddick submitted, it's called the Nickel Continuing Education and Consulting 2013 Case Law Update in Tennessee Workers' Compensation. It was for 10 hours. The only information he submitted was a certificate of completion. We have no idea what was taught. We're not familiar with the company that taught it. I've sent an email to that company asking for a course outline or additional information. We have not gotten a response. The recommendation the committee made this morning was to hold it and not make a determination today, and then if we do get the additional information, we'll review it at that time. So it's not really denied. We had hoped to set it up where if we do get the information, we can send it out to the committee members so they can review it. Yes, David?
Time frame or limit on when they could reply?
I-
Like 30
you
days
can.
opposed to 90 or 220 or 60?
If
or
you want to tell them they have to, if you want to put
30
in.
days would be my
30
recommendation.
days, okay? If we don't get a response in 30 days, it's denied?
I'd see they're not serious about complying.
Yeah, do we have to bring it back to?
That's what I'm asking. Do we have to bring it back to the commission? Or can, I know you can't make a recommendation as a committee without having a public meeting. But if we do get a response and it looks comprehensive, it's only 10 hours. It wouldn't meet all of his education. Would that be something that we could approve in-house? What do you think, Minnie? Huh?
Want to make a motion here and vote on it?
Well, that's why we're,
That's what we're
Trying
trying
to
to, we're trying to avoid that, aren't we?
No, we're trying to adopt a motion, which Commissioner Russo had worked on previously when we were in.
do we
that would
want to handle
cover all
this one
this.
case separately than everything
We
else?
should, I
Let's do
believe.
that. Let's move this out. Okay, we'll move that to later in the report. We had organizations have submitted these items for approval. We have the Investigators Mid-American Regional Conference. It's sponsored by the Kansas Association of Licensed Investigators, March 27th and 28th in Kansas City, Missouri, for 16 hours. The recommendation was to approve that. Rick Mullinax has submitted, he's an approved provider already. He submitted a 12-hour in-person course on executive protection and bodyguard training. The recommendation was to approve that for 12 hours. National Resource and Training Services is an approved provider. They have submitted one new course called SCAMS. The in-person version is 3 hours and the online version is 1 hour. And they also submitted their 2014 training schedule. The recommendation was to approve that. PIeducation.com is also an approved provider. They have submitted a 2-hour online course, Introduction to Accident Reconstruction. The recommendation was to approve that. The Tennessee Association of Licensed Professional Investigators has submitted a 1-hour seminar to be offered at their monthly meeting on March 10th. Divorce Financial Settlements, the speaker is Rosemary Frank. The determination and recommendation was to approve that. And the Tennessee Association of Professional Process Servers is having their 2014 annual convention on March 15th. It's here in Nashville, and it's was submitted for 6 hours. The recommendation was to approve that. So what I would need is a motion to approve the ones that were recommended for approval.
Did I hear a motion to approve them? This is with the exception of nickel, correct?
So move.
Motion by Commissioner Rich, second by Commissioner Valentine. Any discussion? All in favor?
Aye.
Oppose? Motion carries.
All right. On Reddick, the workers' comp seminar offered by Nickel Continuing Education and Consulting. Mr. Russo?
Madam Chairman, I'd like to make a motion that we table a decision on that pending course within 30 days.
Is there a second?
I'll second that.
Motion by Commissioner Russo, second by Commissioner Flair.
Question,
Questions?
is that then approved once they respond, or do we have to have another meeting?
I would submit.
End your motion.
In the motion that we table a decision pending additional information within 30 days to be handled by staff.
I'll second that amendment.
Motion by Commissioner Russo, second by Commissioner Flair. Any further discussion? All in favor?
Aye.
Oppose? Motion carries.
That concludes your education report.
Okay.
I will add one thing. I have been invited to speak at the EPIA. There are also many. I got TALP, ETA, that the TPIA, Tennessee Professional Investigators Association. I'm going to give like an hour-and-a-half presentation on March the 8th in Knoxville. I'm going to give a brief commission overview that just explains the Sunshine Law and how you guys can't talk about these things and how the complaints are presented anonymously. I'm probably going to do about 30 minutes on the reciprocal agreements. And then just a real brief overview of the ethics rules. Scheduled for March the 8th.
We're lucky to have you.
Make us proud, and we know you will.
Gee, thanks.
Everybody should attend. Okay, do we have any unfinished business? Okay, what about new business?
Like Ms. Greer's going to make it to this meeting.
Okay, then I'll go on and see if we've got any continuing education participation. Anybody signed up for that?
I didn't see anything back here. Do any of the continuing
Well, I'll ask our Assistant General Counsel, Josh Kilgore, if he'll handle this item, please.
Just a second to look it over.
Absolutely.
Norman, get up and just explain it? Or-
Would you mind stepping up here and explaining this yourself? Here's your, okay.
I need that back, so.
Oh, we'll need that back, though. Thank you.
I'm Norma Tillman, the new president of the Tennessee Association of Licensed Professional Investigators. We would like to ask for permission to submit a list of topics for pre-approval for us to get credit at our monthly meetings. And I would like to include the other two associations in Tennessee. For instance, we have a qualified speaker this month that has been approved, but we aren't going to meet again before your next meeting. So could we submit a list of qualified topics by qualified speakers? So if one speaker cancels at the last minute, we can substitute another qualified speaker and still receive 1 hour of continuing education at our monthly meetings. Does that make sense? Right now, we've only been approved for one speaker for one meeting. I'm just saying we should have asked, could we submit a list of topics such as divorce, child custody, insurance fraud cases, criminal defense, anything that pertains to what a private eye would investigate. If we have a qualified speaker, and qualified defined means one that has over 5 years of experience in that field, or one who is already certified as an expert. So if we get those type of speakers, we don't want to have to submit every month because the speaker might cancel on us. Can we submit a list of topics to be pre-approved and that we have qualified speakers at our meeting and receive 1 hour of continuing education?
Well, I'll defer this to our attorney here. We normally, this is sent to the staff brings it to the board.
So what I had suggested she do was submit them and then we could send it out for review.
Right.
But didn't have to be voted on?
And that's what I would think.
Well, at
yes.
the next meeting, you should have a list of their speakers for the rest of the year or their topics. And you can address it at that time.
Chairman, but didn't the lady say that we're not going to meet?
Till May. You want me meeting again till May, but we're having a meeting before then. But
And she only submitted
we've only
one.
got one speaker qualified right now that's been approved.
Do you have the other names of the qualified speakers that you would call upon in case you get a no-show?
We would probably have a list of speakers, or if they are pre-approved, such as an expert in their field. Like, let's say, for example, we have a criminal defense attorney who's going to speak, but at the last minute he can't come. Can we get another criminal defense attorney with the same qualifications and substitute without having pre-approval of that particular speaker?
Several names, I see that we could do it that way, but I don't see how we could just blanketly approve person or persons are.
Didn't you mention you wanted this for the other organizations?
Well, I haven't discussed it with other organizations, but every monthly meeting we have, we get no credit. We may have a very qualified speaker there, but we're not receiving any credit for it. And I'm sure the other two associations would like to be approved also.
Well, that's something they'll just have to submit to the executive director and then it be brought before the board. I mean,
Possibly schedule your meetings like 2 or 3 months out and bring that all to the next board meeting. And
I would love to, but the speakers cancel on us even after we get them approved. You know, this next speaker, at the last minute, something could happen and she won't be able to speak. Can we substitute another speaker with the same qualifications?
One way to handle that is that you bring those speakers before the board that have already spoken, and we can approve those as continuing education credit.
So you want a list of qualified expert speakers, and we can choose from a pool or a list for our meetings? Is that correct?
I think that would simplify it.
Well,
You
okay.
just furnish that to the staff, a list of the topics. You don't have to say topic A is going to be on month 11, and then a list of qualified speakers. Then they've got that pool of resources that they can provide us. We can look at it. And from what I hear you saying, I think once the Education Committee looks at the list of topics and the list of speakers, I don't think we'll have any problem approving it, but we can't give carte blanche authority today because we don't know, we're shooting a
understand.
moving target.
Okay, we'll be glad to do it that way.
and as far as the other organizations, unless they approach and request it themselves, I don't think we should.
Understand.
Okay.
We were supposed to meet today, but the other two some of them were unable to get here, so we were going to discuss that today. But thank you very much. That's all I have to say.
I believe we've covered everything. Could I have a
Chairperson, may I
motion?
make a comment?
Yes.
Next time we meet, bring an extra one of these. I don't have the authority, but I'm gonna recommend that you sprinkle holy water over this one and bury it.
On that note, could I have a
I
motion
need
to
to have a
adjourn?
class on how to operate the iPad.
No one in the building can make this one work. I'm teachable.
Adjourn.
We,
They'll figure it out.
I second that.
we have a motion by Audrey
Made the
Moore,
motion.
Commissioner Audrey Moore to adjourn. It was
You
seconded by
always do
Commissioner Valentine.
I'll second. Let's stop
It's,
this.
it was seconded by Commissioner Valentine. All in favor?
Aye.
Opposed? Meeting's adjourned.